Thank you, Mr. Chair, members. SB 394 will require youth under the age of 18 to consult with the legal counsel before they waive their Miranda rights. Currently in California, children, no matter how young, can waive their rights. Additionally, the existing public safety exemptions, when Miranda rights can be disregarded, will not be changed by this bill. I respectfully ask for aye vote.
Thank you. Are there any witnesses in support? You have 5 minutes or less. Ready?
Yes.
Go.
Short.
Chairman and members of the committee, thank you. My name is Jerome Dixon, and I am here in strong support of Senate Bill 395. I live in Los Angeles, where I'm a project manager for a construction company. I am currently overseeing 5 major remodels, and I'm also an avid marathon runner. I'm also someone who, as a teen, was interrogated by the police. It was one of the worst experiences of my life. At 17, I was taken to the police station and put into a small room. There was just one sliver of a window in the room, and that was taped over with a piece of cardboard on the outside of the glass, with only a small peephole cut through it. I was interrogated for 25 hours. During the first 5 hours of being questioned, I gave the investigating officers a detailed outline of my day's event up until the point to where I was placed in the backseat of the patrol car. I spoke the absolute truth. They were kind to me, but kept questioning. By the 10th hour of my interrogation, the officer's attitude changed. He moved from being comforting and engaging to provoking. He told me that my truth was a lie and said that I needed to stop playing games. By the 15th hour, I was so exhausted I couldn't have told you if it was night or day. The police had a story about what happened, and they wanted me to put myself into the equation. At hour 21, I just wanted to go home to my family. And by the 25th hour of the interrogation, I was mentally and emotionally drained. I became an empty shell of a child, and I gave up my will to fight and explain the truth. I told the officers what they wanted to hear. The interrogation ended. I confessed to a crime I didn't commit, and what I didn't understand at the time was that I made a statement that would later be used against me in court. Maybe some of you listening right now can't really comprehend how a 17-year-old can give up his rights and be worn down to the point of confessing to something that he didn't do. But I never understood what those rights were or what it meant to give them up. I didn't understand what could happen if I just agreed to everything. I made a legal decision based on extreme fatigue and youthful ignorance. I was convicted based in part of that confession. I was tried as an adult, and I served 21 and a half years in prison. I never had a single disciplinary action in prison. In October 2011, I was paroled. I strongly support SB 395 because no young person should make an uninformed legal decision, one that could cost him 20 years of his life. I respectfully ask your yea vote. Thank you.
Thank you.
Mr. Chair and committee members, I am Rourke Stacy. I'm a criminal defense attorney and juvenile law expert. I've represented hundreds of children in both juvenile and adult court, and I've argued 2 seminal juvenile law cases before the California Supreme Court. My expertise regarding youth and interrogation settings led to the International Association of Chiefs of Police to have me on their national training team to help train law enforcement how to treat youth differently in interrogation settings. It's my experience in training law enforcement and working with children that lead me to strongly support this bill. Briefly, Miranda was created in 1966 for adults. It was intended to be a completely prophylactic and preventative measure. Unfortunately, at that time it was created, it was never intended to be used on youth. In fact, youth did not have the right against self-incrimination until the following year in 1967. The reality is, in order for the preventative aspect of Miranda to work, you have to understand the rights. The problem is that most youth do not understand their Miranda rights at all, and therefore they're not really being afforded the constitutional protections and the prophylactic measures that were designed by the United States Supreme Court when they created the Miranda rights. As a result, when they're not getting these protections, we have to figure out a remedy in our state to provide that protection. SB 395 provides that remedy. It provides counsel, consultation with counsel prior to the actual interrogation beginning. It would not apply to involuntary statements before the interrogation, nor would it affect the current public safety exception that we have in California to Miranda. What it would do is provide a developmentally appropriate protection so youth can properly understand their Miranda rights. It is the outdated mentality that all youth understand Miranda that led California Supreme Court Justice Goodwin Liu to urge legislative action to address providing protections to youth in interrogation settings. Therefore, I urge you, all of you, for an aye vote on this bill.
Thank you. Any witnesses in support, name and organization?
Dave Nielsen, California Alliance to Child and Family Services, strong support.
Wesley Edwards with League of Women Voters of California, and strong support.
Bill Oscar for Compton Unified School District, in strong support.
Diana Campos on behalf of the California Catholic Conference, in support.
Sawait Siyum on behalf of the California Public Defenders Association and Public Interest Advocacy, in support.
Melissa Immel on behalf of the California Academy of Child and Adolescent Psychiatry, in support.
Maddie Hyatt from California Civil Liberties Advocacy, and support.
Lynn Wu from the Prison Law Office, in strong support.
Elizabeth Espinosa on behalf of Los Angeles County Board of Supervisors, in support. Thank you.
Maureen Washburn with the Center on Juvenile and Criminal Justice, in strong support.
Akil Ochoa on behalf of the Anti-Recidivism Coalition, proud co-sponsor, strong support. Thank you.
Patricia Song with the Children's Defense Fund, California, in strong support, also as a juvenile defense attorney, in strong support.
Rosa Akil on behalf of the Alliance for Boys and Men of Color and Policy Link, in strong support.
Gloria with the Youth Justice Coalition, in strong support.
Vanessa De Leon with the Youth Justice Coalition, in strong support.
Frankie Guzman, National Center for Youth Law, in strong support.
Blair James, Anti-Recidivism Coalition, strong support.
Michelle Murray with Cares for Youth, in strong support.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, Statewide Association of Criminal Defense Attorneys, co-sponsor of the measure.
Rebecca Gonzalez, National Association of Social Workers, California chapter, in support.
Lizzie Beacon with the ACLU of California, in support.
Daniel Herron, Anti-Recidivism Coalition, strong support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California, in support.
Good afternoon, Ella Baker Center for Human Rights, in support.
Thank you. Are there any witnesses in opposition?
Members, Marty Veronica on behalf of the California District Attorneys Association. We're opposed to this measure that would require that the juvenile consult with an attorney before any custodial interrogation and before being able to waive his or her Miranda rights. This measure would frustrate criminal investigations and cast doubt on voluntary confessions made by juveniles. As noted by the bill, juveniles already have a generous interpretation of their Miranda rights, requiring the court to take into consideration juveniles' age, education, and immaturity in deciding whether the Miranda waiver itself was voluntary. Even Justice Sotomayor, in the case of JDB versus North Carolina, recognized that although a child's age must be considered, not in every case would age be the determining factor in deciding the voluntariness of the Miranda waiver. By declaring that anyone under 18 must consult with an attorney before waiving their Miranda rights, this measure makes age the only determining factor. In addition, This bill is identical to last year's measure, SB 1052, which was vetoed by the governor. His veto message is telling. While he looked closely at both sides of the issue, he also stated that in countless cases, police investigations solve very serious crimes through questioning and the resulting statements and admissions that follow. We were opposed to this measure last year, and we're continue to be opposed to this year's version. Thank you.
Thank you. Any?
Good afternoon, Mr. Chair and members. Usha Machlar on behalf of the California State Sheriff's Association, respectfully in opposition to this bill. We have a number of questions that we have raised, and I believe they're echoed in analysis, including who will serve as a counsel to the youth who waive their Miranda rights, what entity will pay for it, and why is it being mandated even in cases before a person is arrested. Law enforcement may simply want to talk to a minor, and even if the parent or guardian is notified in advance, this discussion would have to wait until counsel could consult with the minor if there was a chance that the interaction could fall under the bill's undefined umbrella of a custodial interrogation. And for these reasons, we respectfully oppose. Thank you.
Thank you. Any other witnesses in opposition? Thank you.
Chair members, Jonathan Feldman with the California Police Chiefs Association, opposed.
Thank you.
Cody Boyles on behalf of the California Probation Officer Association, opposition. Thank you.
Thank you. Are any comments from Ms. Gonzalez?
I'm really hungry, so I must really want to comment on this bill. I just find it extremely rich that the San Diego DA would oppose this bill when the way she assumed office was because of a case involving basically Miranda violation of 14-year-old boys in the Stephanie Crow case in San Diego, which changed my life as a woman growing up. My kids, from the day they were born, will tell you they have been told time and time again that you never waive your right to an attorney, especially if you didn't do not just because you didn't do anything. So for a case that was so prominent and continues to be so prominent in the legal discussions and the DA discussions in San Diego, it's the very reason I think this is an important bill, and I'll be supporting this bill, and it's just ironic.
Thank you. Any comments? Mr. Lara, you may close.
Thank you, Mr. President. I also, just reflecting back, I'm glad I was a good undergrad student in San Diego, because if I made a mistake, God knows what would have happened to me. Members, again, children are different than adults. A recent study, again, of exonerations under the University of Michigan Law School found that 13% of adults have falsely confessed, compared to 42% of children who have confessed for crimes they did not commit. The ramifications for both the individual and society of false confessions are far-reaching, and with that, I respectfully ask for your aye vote. Okay.
And thank you, Mr. Lara, and thank you for promoting me to president. And I'm pretty sure that's just wishful thinking on your part.
It's that suit, golden.
The chair's recommending aye vote. Call the roll.
The motion is due pass on SB 395. Jones Sawyer?
Aye.
Jones Sawyer, aye. Lackey? No. Lackey, no. Flora? Flora, no. Gonzalez Fletcher? Gonzalez Fletcher, aye. Rubio? Rubio, aye. Santiago? Santiago, aye.
That measure passes.